Hi there. We're going to start in just a couple minutes to allow everyone to join. Thank you so much for joining us today. Again, we will be starting in just a couple minutes. I am sharing my screen now, so if you are having any issues hearing me or seeing me, on your right-hand side of your panel, you'll see that there is a questions and chat section. Please feel free to use those, both for asking any questions for the end, or if you're having any sort of troubleshooting issues with the presentation. We'll be starting in just a couple minutes. Thank you. For those of you just joining, we will be starting in just a couple minutes. We just are allowing everyone to join the webinar before we start. If you have any issues seeing my screen, please use the chat or the question section on the right-hand side of the webinar panel. And again, if you have any questions or issues, please use the question or chat function. We will be answering questions at the end. I will be starting this in just a couple minutes. Thank you so much. For those of you just joining, we're just going to wait 1 or 2 more minutes as people are joining the webinar today. As I've mentioned, on the right-hand side of your panel, you will see that there's a questions and a chat section. If you have any issues either seeing my screen, or if you can't hear me, then I guess this won't work. But if you are having sound issues, please let us know. And then if you have any questions during the presentation today, you can stick those in the question section. We will be answering those at the end of the presentation. I'm just going to give everyone just another minute or 2 to join. Thank you so much. All right, everyone. Well, we'll get started. My name is Rojine Mozafarimer. I've probably spoken to all of you at some point. I'm an associate attorney here at MPLG and the primary H-1B contact. We are discussing public access files today, and as many of you may know, public access files are a very important requirement for not only H-1Bs, but your H-1B1s and E-3s that some of you employ. Today we will be doing a short webinar just going over the requirements for public access files and help you basically create the templates to make the creation of those public access files fairly seamless. You will see on the platform on your screen that there's a section that's called Handout. We have there a document that has all the templates for the public access file sheets. This might differ from something you had from us maybe a year or 2 ago, and that's perfectly fine. We've just updated it recently. You can have varying versions. This is just our updated version of that. So you can also download a copy of that for your use as well. Okay, so why a public access file? So the Department of Labor and the USCIS require that there is a single file evidencing compliance with the H-1B laws that is readily available to the public or the Department of Labor. And so when should it be created? It should be created within 1 day of filing the LCA. So for many of you who filed H-1Bs with us, you will see that we send a very lengthy email when we send our LCAs for posting. We'll talk about those requirements in just a minute. But in there, you will, the way the email works, you have a timestamp that you'll be using that as well, and we'll talk about that. And once you have confirmed posting, you should start creating the public access file. Public access file should be kept on site at your primary business location. You might have employees that are working off-site or at remotely, but all public access files should be in one location at your primary place of business. They should be kept separate from your HR and personnel records. So if you have your HR and personnel records set in one section, you should have another drawer or another file that's specific to public access files. And then finally, what goes in there, and we're going to be talking about this primarily today, the certified LCA that's signed and dated, the rate of pay for the worker. I say H-1B, but this also does include H-1B1s and E3s, an actual wage memorandum, prevailing wage determination, proof of the LCA posting, and a benefit summary. So a table of contents, we recommend having a table of contents. It just helps sort of keep you in check as a checklist of everything that's need to be in the public access file. And for anyone who does request the public access file, they'll see exactly what's in there. So again, if you don't have to have the original of the certified LCA, you can have a photocopy. And then again, the list that we've discussed, certification of the LCA posting, a wage rate statement, actual wage memorandum, prevailing wage determination, and sample benefit summary. I assume that most of you put the whole LCA in there. There are certain situations where the entire LCA wasn't posted, you do a sample posting. Okay, let's start with the first page, which is the LCA posting notice. So you'll see the LCA number. When you're initially posting, you will see that the LCA number will start with the letter T. After it's certified, it does change to an I. So when you're completing this, you can have it with the I, and you do have to post the LCA in 2 conspicuous places. And so what does that mean? So you could have it, somewhere in your kitchen, at your, workplace, some sort of board, a bulletin board for announcements. Another place that is also okay is that LCA filing may be posted electronically. So it could be sent directly by email or electronic newsletter, or posted to a company homepage on either the internet or the company's intranet. So when you're listing where they've been posted, let's say you have an intranet system that you want to use, you can say the intranet system, and then if you have that bulletin board in the office, you can post it there as well. Then the notices, you have to have them posted for 10 consecutive business days. So this is where that handy dandy email where you respond to us comes in. The day you confirm that you've reviewed and posted, you have a record for yourself in your email of when that posting date started. So that will be your start date. You would count 10 business days and then add that end date. And you would just have the authorized signatory sign this page. Fairly straightforward. Next, the wage rate statement. So there are various versions of this document. It doesn't have to look exactly like this, but this is where you confirm exactly how much the employee is going to be paid. So let's say you have the LCA with a start date of June 1st, 2018, and they're going to start work for you. You can have, you put that date in there, you have their name in there, and then you do their actual wage. And usually we file cases by year, but there might be situations where it's weekly or hourly, and you'll have their job title that's also listed on the LCA. Fairly straightforward. Now, the actual wage memorandum. So there are other versions of this that are also around, but this is a very succinct version of it. And basically what the Department of Labor wants to see is how you arrived at that wage level. So this document, it's also in that Word document that you see, is a template version of how a company would evaluate a wage. So it basically states that salaries are paid and evaluated by level of education, year of experience in the field, job responsibility. And if there are other factors, please feel free to add those in there. And then we do recommend that you put in there a statement about when salaries are adjusted and how they're adjusted. So if it's based on performance review, cost of living adjustments, so we have that in there for you. And so you also want to make sure that you have a statement in there that says that you are applying the same methodology to all US and H-1B employees when determining the actual wage. So you want to ensure that you are not making any sort of difference or accommodations based upon someone's immigration status. Okay, the prevailing wage notice. So this is where you actually start having to add an actual document in addition to these templated pages to the file. So when you have the LCA, you will see that we've had conversations about the prevailing wage. And so you'll see we have pulled up the software developer applications as an example on the screen. And here on the LCA, we do have the wage level and we also have the wage rate. So here you would take not the actual wage. So let's say you're paying someone $110,000 a year for a software developer role. You would actually put that on the previous notice that we just discussed, but you'll see below that on the LCA, it'll say the prevailing wage. And here you will see that the prevailing wage would be at a level 2 at $109,325. So here at the highlighted section, you would put in $109,325. Then the second part is the source of the prevailing wage determination. So we always, 99.9% of the time, use the online data center from the Department of Labor to do this. The year always has to be indicated. If you may know that every year the Department of Labor updates the prevailing wage on July 1st. So right now we are operating still through June 30th on the 2017 wage library. So this is also indicated on the LCA, so you don't have to make this a guessing game, but for your information of what to use, because that's important, because you actually have to go to the online data center and print out this page on the right. So you'll see there's a link there for the FLC data center. You will look it up by the SOC code, which is listed here above the title, and your metropolitan statistical area. So it's listed by county. So for example, for us, we would look up Alameda County. We'd stick in this SOC code for software developers, and we just print this page out. So you might be updating your public access files, and you might have someone, for example, who's 2016, you might not have that sheet in there. There is a mechanism to find archival data for H-1Bs on this site. If you have any questions about that, please reach out to us, but you definitely want to be printing out this page to include with this prevailing wage notice. The benefit summary. So here you just want to have this templated language about how you offer benefits to all employees of your company. Your company may not offer benefits at all, and we've come across that. You can make a statement saying that, we don't offer benefits, but you have to make sure that there's no differentiation between H-1B professionals and other full-time employees. So what you would do is you would just print out this page, and then you can have your insurance provider provide a benefit summary, and that would be the same copy that you would just use and stick in there for each person. So just taking a step back, so it seems like there's a lot of documents that we would have to print out. What we recommend is that Word document that I have uploaded in the handout section, if you save a version of that remotely and you just update it, you have a file that you save, you can easily just update those sheets and just print them out, so it doesn't have to feel like you're creating this from scratch each time. Some companies might only hire software developers, or you might have two types of employees, software developers and data scientists, for example. You could have two Word documents that you've already pre-created for that, and then all you would have to do is update the LCA number, the name, and the wage information. So it ends up being sort of a 5-10 minute operation that one day after the LCA to create this, and then it's just a print job. So here is what I think is the most important item about this, especially in light of the current administration, and we'll talk about that in just a little bit. Again, the public access file must be created after the LCA is initiated. You might have, for example, CAP cases where you don't know if someone's selected yet, and that's perfectly fine. You do need to create those public access files. If they don't get selected and that case gets rejected, and you can then get rid of it. You don't need to have it anymore if you have they never become a current employee, and we'll talk about that. So you must always have a public access file for each current employee, and it must be current based upon their current employment. So for example, you might have someone who has an approval notice through September 2018, and you are filing an extension for them. That, let's say you filed the extension yesterday, your public access file should have that information for the extension in there. You might be filing an amendment. Once you initiate that amendment, you should create the new public access file and update that for them. Every employer must maintain records for at least 1 year. And that is for cases where you might have an employee that left last summer in July. You should have that public access file on site until July 2018. If there is a wage issue and the Department of Labor is engaged in, which, you know, we don't face that very often, but it is something that you should be aware of. If there's a complaint filed, you must hold on to that public access file. So you might have a situation where someone might issue a complaint and they've already left and it's been over a year. You should hold on to that public access file until the complaint is resolved. So LCAs. So during CAP season, for example, you know, we might be brainstorming about what makes sense for potential employees or candidates for October 1st. So you might have multiple LCAs that either were used or were not used. You might have situations where a case was initiated, but we didn't go forward with it. We strongly advise withdrawing unused LCAs with the Department of Labor, and all that means is you let us know that you would like us to withdraw them. It keeps it very clean in terms of your records with the Department of Labor. There's no official issue with having LCAs sitting there and open, but you want to have an accurate portrayal of who you're actually employing and offering work to under the H-1B, the E-3 or H-1B1 programs. Finally, for former employees, so we strongly advise withdrawing any LCAs for former employees if the LCA validity period remains current. So you might have someone who has been laid off or resigned, let's say yesterday. The LCA validity period is through September 2018. We strongly recommend withdrawing that LCA, again, to keep a very accurate record with the Department of Labor with regard to your H-1B and E-3 and H-1B1 employment. So, you know, I find public access files to be sort of the awkward child of the H-1B program because it is about compliance. We don't like being the, you know, compliance police. That's not our job, but we're here to make your immigration programs strong and in the event of a site visit, in the event of any sort of visit. So at any point, just to give you a little bit of background of why we even do this, besides the fact that the rules say that you need to do this, any member of the public can come visit your business and ask to see the public access file. And so you actually, by law, have a full business day to respond to that. So you want to make sure you have that. So that's in the regs. That's, you know, there's no way around that. You know, there's always been random site visits for compliance purposes for the H-1B program specifically, but under the new administration, additional site visits have come into play. So as of April of last year, the president signed the Putting American Workers First program, and the USCIS is now, in addition to doing their random site visits, they're going to be doing targeted, and they have been targeted site visits for several types of specific cases. Those are cases where the USCIS cannot validate the employer's basic business information through commercially available data, and I'll talk about that in a minute. H-1B dependent employers. Those are those who have a high ratio of H-1B workers as compared to U.S. workers as defined by statute. We'll talk about that. And employers petitioning for H-1B workers who work off-site at another company or organization's location. So that's consulting companies and off-site employment. So we have seen that they've started doing these targeted site visits. You want to make sure that you just have your records in play and in tip-top shape. We do public access file audits for our clients. So if you do feel that you want to do a quick checkup on that, we do offer that, and the summer is a great time to do that before your CAP employees go into effect on October 1st. So to circle back on sort of the types of targeted site visits that are taking place, for cases where USCIS cannot validate the employer's basic business information. So some of you may have heard of Dun & Bradstreet. Whenever we do our corporate initiation with you, you'll see that we ask you to make sure that your address and business information is correct in Dun & Bradstreet. If you just go to their website, you can do a company search and check that. The USCIS, they use something called the VIBE program, which basically the way that they look up a company's information is through Dun & Bradstreet. It's a little antiquated, but that's what they use. You will see that, for example, you might have moved in the last year. Dun & Bradstreet might not be updated right now, and they will issue RFEs for situations like that. So to sort of, in addition to having your public access files in compliance, you want to make sure that you have your address and business information correct in Dun & Bradstreet, so you avoid being one of the targeted businesses for site visits. So H-1B dependent employers, there's nothing wrong with being H-1B dependent. There are additional attestations that most of you know that have to be taken with being H-1B dependent. That's indicated on the LCA. We always, you will know that our senior paralegal, Shana, always asks your employee head count whenever we file an LCA. It's also in our initiation worksheet. But that is something where they will do site visits. So it is not a negative thing to be H-1B dependent. However, it's even more critical to make sure that your records are in order for those potential site visits. And then finally, employers petitioning for H-1B workers who work off-site, so consulting or working at a client site, they are doing targeted site visits for that as well, so they can come and check the records there. All of this is, these are things that haven't been fairly new for us. We've been giving a lot of warning about this over the last 1.5 to 2 years, but we believe that especially in light of this current administration, it's even more important to have your LCA records, in compliance, your public access files with all the documents. So again, I said it was going to be a short presentation, but a very important one. I will open the floor for questions. As I mentioned, on your panel, you will see that there's a box where you can insert your questions here, and we will answer them as they come in. We have a question here about whether to, should you have a digital file versus a hard copy file for your LCA? That's a very good question. We still operate with the fact that you should have hard copy files. Having a digital scan does not hurt. You can start, everything is moving to be electronic. I feel like the last frontier for technology is the USCIS and immigration, but we unfortunately still operate with the recommendation that you should have hard copies of all those files. Having scans do not hurt. You can instantly print them, but in the interest of conservatism, always have the hard copy file set separately from your HR personnel records. So I have a question here about when you're doing the wage rate statement, if you don't know when the person's start date's going to be. And that's a very good question. On the form I-129, we indicate the start date on page 5 of that form. You would just put in that start date because that's what directly aligns with what we're requesting with the government. So you might have a CAP case that, starts October 1st. That's the date that we ask for. You would indicate October 1st for that date. I have a question here about, I haven't been keeping up with my public access files. What do I do? We're here to help. So I'm hoping that the handout that's here helps you sort of start creating them. If you have cases that you need to create those public access files that are for, the last year or two, create them. The notice posting dates, as I mentioned, email is amazing for record keeping. So you can find the posting dates for that and completing them. For the actual wage stuff, so you might have a record that you need to create from a 2016 prevailing wage. OFLC has that information for you, so you can use that. Okay, so I have a question here about, what about non-selected CAP cases? So this is a very good question. You want to hold on to those. And in the interest of conservatism, so even though you're not employing them in H-1B capacity, you, until October 1st, you have to create the public access file from the day after the LCA is filed. So we filed your LCAs for CAP in February, March. You should be creating the public access file. You should have had them created, or if you haven't, create them now. Hold on to them, and even if they are rejected, in the interest of conservatism, hold on to them for a year. Just hold on to them for a year. And so for the non-selected ones, because you will never be employing them in H-1B status, you don't have to hold on to them. But for anything where you create them, they're selected, you hold on to them as they're employed, and then once they stop being employed by you, start the clock, you must hold on to those records for 1 year. I have a question about amendments and extensions. So you might have employees who've been with you for, 5-10 years, and they have their I-140s, they're waiting for their priority date to become current, and so they have a number of extensions and amendments. So what records do you keep? Every time you initiate a new case, that public access file, a new public access file needs to be created. So you don't want to necessarily keep the old record, you want to have the most current record on file. So if you have an extension that you just you're initiating today, when the LCA is posted today, create that public access file, a new separate one tomorrow. So you don't have to have 10 years worth of records, you want the current record on file with you at all times. So again, I want to just clarify, I'm sorry if it hasn't been clear. For record keeping, current employees, you keep the most accurate current information about the current position and per the terms and conditions of the H-1B that was filed. So if you have someone who's working as a solution architect and that's what the LCA says, and that's what the H-1B was for, that public access file should reflect everything from that most recent petition. If the employee has left, you need to hold on to those records for at least 1 year from the day after they no longer are employed by your company. And if cases have been rejected, and they've never started the employment, you don't have to hold on to them because they have never joined you as an H-1B employee. This is only for people who have actually joined you as an H-1B employee. I know that kind of contradicts how CAP works, but CAP is an anomaly because we face a lottery. So you must keep those records until you know whether they've been selected or whether they've been rejected. I have a question here about whether you use the case number only or the person's name for the public access file. So if you take a look at our handouts, and also I can go back on our slides to find it for you, but basically there are pages where it's only the LCA number. There is only one page, which is the actual wage statement, where you put the person's name in there. And that's to say that this person, this employee for which this LCA is assigned to, they are being paid this actual wage as of this date. You do not have to identify the actual files by name. So the actual hard copy files that you keep separately, you do not need to have those by name. You could just have them by LCA number. So I have a really good question here. If 2 amendments are filed for one employee and none of them have been approved yet, which public access file should we keep? You should, for any case that's pending, you should have both public access files until what's called the last action has been taken on this person's record. So what does that mean? You might have a case where someone has a petition filed for one location, for example, and that case was filed in regular, it's still pending. Let's say that project's over, they need to move over to another client. And this doesn't mean change of employer, this is with the same employer. You will have to create a new public access file. Because they're still pending though, you have to hold on to both of them. There might be a situation where one might get approved before the other. You want to have the most up-to-date records at all times. Keep both until the final one has been approved, and that's the one that they're working pursuant to. And then finally, I see a question here about what to do after that 1 year. Do we shred the public access file? Definitely. You don't have to keep them anymore. You can do whatever you'd like with them. I do have some clients who retain them for more than a year, but that's for their own internal policies that have to do with employment stuff. That has nothing to do with immigration. After the 1 year mark has passed, you have no obligation to hold on to that record anymore. I have a very good question about non-compliance. So let me pull up some data for you if you give me 1 second so I can let you know. 1 second. So where did the numbers go? Okay. So because the employer has an obligation to produce its LCA documentation to any requester or the Department of Labor may investigate an employer's LCA based either on a complaint from an aggrieved party or on its own initiative. If the Department of Labor finds that an employer has violated the LCA requirements, such as through willful failure to pay or a substantial failure to post the back payment of back wages, there could be penalties, including a $1,000 fine per violation. So that actually has to do with actual violations with LCA information. In terms of not having your records, if you haven't made a good faith effort to create your records, the Department of Labor can take action against you. And those are in the form of fines. So we have, there have been situations where Department of Labor have caught an employer who's just moved from one building to another off guard, and it's been several months and they're still finishing the moving in process and they haven't updated public access files. In the past, we've seen leniency with the Department of Labor to allow them to update the public access files. However, under this administration, we wouldn't risk it. They do have the authority to impose fines for not having public access files because you are therefore in violation of the H-1B regulations because you have a duty to have them. This isn't a discretionary or a policy that you're trying to align yourself with. This is an actual law that a regulation that you have to meet. I have a good question here. So if we find an error or omission in creating a public access file in the past, can we create a new one now for the past record showing good intent with at least partial documentation? So let me see if I'm interpreting that. So let's say, there's a couple scenarios that come to my mind. You might, have not updated someone's public access file, or you might have neglected to include one of the required documents in the public access file. And so let's say, after this, you go do your own internal audit and you realize that things are missing, or you have us come in and check in your public access files and we identify that. It's a good time to create it. It's your records and you guys know when you've created them. So long as the Department of Labor, doesn't visit you at a time where you haven't fixed them, or, the goal is to have them fixed. So let's say you go through your public access file, you see that it's missing an OFLC printout. Go ahead and print it out from that year, stick it in. That's the right thing to do. Let's say you don't have an LCA, but you need it, reach out to us. We should have that record, but you should have those in your records from all the petitions that we share with you after each filing. You might not have a public access file for someone. Create it, check your email for posting dates. If you're having issues, reach out to us. But there's nothing wrong with creating things that you are aware of today. The best thing to do is to get yourself compliant. I have a question here about whether MPLG creates public access files, and we do not. We do not provide that service, and a lot of that has to do with the fact that this is an internal business compliance issue, not an immigration piece in terms of a service that we provide, because this is information that has to do with your attestations to the Department of Labor. And so we can't make those attestations on your behalf. But what we can do is we can, if you see a public access file that you're unsure about some information, we're happy to look at that. We're happy to audit. We provide those services. We will do whatever we can to assist you to make sure that your public access files are in order. So there, I see a question about documentation in the past. So you might have a situation where you have the certified LCA and not the initiated LCA, and you may not have the posting date. So again, we can't advise you to how to find those posting dates beyond, you have to search your records. You can, ways that you can kind of figure out when things were posted. We have if you can't find it in your email, something else that we do is if you look at the date that the LCA was certified. So you might see that you got a certification email, because you get those emails on like May 10th. You can count, it takes about 7 days to certify an LCA. You can try to count days that way. You get emails when we submit the LCA. You get an email from the Department of Labor. That would also be something. I would check emails about, conversations that you've had with your attorney about LCAs. Those are some options for trying to create public access file data that needs to be updated for past public access files. Okay. And then just a final note, I guess, with all of this. As I mentioned, I feel like public access files are this sort of weighty sort of subject that of more work for the HR, more work for the contact that, the immigration specialists. And I strongly advise you take that handout that I've uploaded there and you save that. And let's say you have 3 types of employees, or you might even have 10. Create those templates for each position. And then it ends up just being sticking a name, sticking a wage, and then also the LCA number. OFLC is very easy to use, the search function. If you have any issues with that, call me, email me. We're really happy to help you with that, especially under the new administration with targeted site visits. We keep hearing about it. We're seeing it. We've actually walked our clients through some of this recently. It is more and more important that, compliance is there. We're here to help. So just reach out to us. One final very good question I see about benefits summary. So benefits might change during the year, like one, benefits might be offered at one time a certain way, and then, you update your insurance provider the next year. Your public access file should reflect what the current information is. So if at the time the benefit summary was that way, you just keep it that way. It does not hurt to update it, but you're not required, because you're saying that as of that date of that public access file, that's the correct benefit summary. If you do have them updated, I know sometimes it does happen, it doesn't hurt to stick that in there. The most important thing here, I will say, is you've made a good faith effort to keep those records together. Public access files are what I call always a work in progress, because every case is different. You might not even be using OFLC, you might be using a different evaluation for prevailing wage, like a what's it called? I think it's called a Radford report. There's different things that happen with each H-1B, but the whole thing is, if you made a good faith effort to create these public access files and the gist of that information is there, you are in a much better position than you are without those public access files. Okay, everyone. Well, thank you so much. I really appreciate everyone's participation and time today. These questions were really great. I know you might have some more questions after this. I'm Shayna Howard, our senior paralegal, as well as myself. We are your main H-1B contacts. We do work collaboratively here. Kalpana, our firm partner, and Amir Sheikh, we all work together on these things. So if one of us isn't available, someone will make themselves available. We have our contact information there. Let us know if you have any questions. If you need audit services, we're here for you. Again, thank you so much for your time.